I suppose now.
Okay, thank you.
Could I ask that everybody introduce themselves so I know who they are?
We'll be
Yeah.
starting off with
that needs to be
some
noted.
instructions.
Wait. Are you recording, Mr. Lindquist?
I am. I was recorded the last time I was at a meeting,
You were.
and I was given permission to record since it's a public hearing.
That is correct. This is actually not a public hearing, but you do have permission to record.
Thank you. I would like to know everybody's names, though. That would be...
Would it be acceptable to you if we stated our names before we said anything?
No, I think we should go around since everybody knows who I am.
They all have name tags.
I know. I don't know who they are. I don't know their credentials. I don't know where they come from.
It's on the board's website.
I know, but I think it's a courtesy to state it.
We
record.
will introduce the board members to you.
Thank you.
June, will you please start? Use your mic, please.
June McLaughlin, Lake Superior College Nursing Instructor. Monica Parks, RN Board Member.
Steve Smith, registered nurse board member.
Michelle Harker, Public Board Member.
Diane Scott, RN Board Member. Cindy DeCharles, LPN Representative.
Natalia Stroud, RN Board Member. Christine Rennie, Public Board Member.
Janine Gagnes, registered nurse board member. Jan Rainey, public board member. Christine Norton, public board member.
Sheila Robley, Licensed Practical Nurse Board Member. Deborah Meyer, LPN Board Member.
And I'm Deb Huggins, I'm RN Board Member. So we're going to proceed with...
And you are?
I'm staff.
You're... Okay, so thank you guys, the rest of you, for introducing yourself. Thank you.
We're going to proceed with the hearing. This is a meeting of the Minnesota Board of Nursing. Today is October 2nd, 2014. We are at 2829 University Avenue Southeast, Minneapolis, Minnesota, 55414, 4th floor, conference room A. The time is now 2:17 p.m. Before the board at this time is the matter of Stephen P. Lindquist, RN, LPN, RN license number 137361-3, LPN license number 48920-7. My name is Deborah Hogginson. I'm president of the board and I'm presiding in the case today. Sarah Basons, Assistant Attorney General, is the board's advising attorney in this case. Would the members of the board's review panel for this case please identify themselves?
Steve Smith, registered nurse.
Mark Amterfeg, board staff.
Would the attorneys for the parties please identify themselves?
Jennifer Middleton, Assistant Attorney General on behalf of the review panel.
And Mr. Lindquist is here, and you have no one else here representing you today?
Just myself.
Okay. The board's advising attorney will make some preliminary instructions.
Each party will be allowed to present oral argument to the board. 15 minutes each will be permitted, including any time the party may wish to reserve for rebuttal. The review panel will speak first. I want to remind the parties that you must confine your argument to what is in the hearing record. You may not add new facts or evidence in your argument or in responding to questions from board members. Members of the board, please confine your questions to the information contained in the record. Additionally, I understand that there are staff of the legislative auditor here, and it is their position that their presence does not in any way affect attorney-client privilege. I just wanted to be clear that the board does not intend to waive attorney-client privilege by having staff members from the legislative auditor here.
Following the arguments, the board's advising attorney will read certain instructions to the board. After the instructions, the advocates will be excused from the room and the board will then deliberate the case. Are there any questions about the procedure? The review panel may now proceed with its argument.
Good afternoon, Madam President and members of the board. Again, my name is Jennifer Middleton. I'm an Assistant Attorney General representing the review panel. The review panel respectfully requests that you adopt the proposed findings of fact, conclusions, and final order for a suspension of 12 months with 12 months of demonstrated sobriety in order to repetition. This order is based on the fact that Mr. Lindquist signed a 2013 consent order which stayed, suspended his license but stayed that suspension so long as he met certain requirements. This stipulation and consent order was based on previous mental health and chemical dependency diagnoses. Mr. Lindquist agreed to that stipulation and consent order, and it took effect. As part of the stipulation and consent order, Mr. Lindquist had to enter into the Health Professional Services Program. On November 8th of 2013, Mr. Lindquist did sign a participation agreement and monitoring plan with the HPSP. That monitoring plan required him to abstain from the use of alcohol and controlled substances, as well as to provide toxicology screens at the request of the HPSP following their screening protocols. On December 27, 2013, Mr. Lindquist submitted a required toxicology screen, and the results came back dilute. Discussion was had by the HPSP case manager with Mr. Lindquist regarding the dilute screen, and information was provided to him on how to properly hydrate so that screen results are not dilute. Again, on June 25th of 2014, Mr. Lindquist again submitted a required toxicology screen, and the results were again dilute. His case manager at the HPSP spoke with him again about the dilute screen. Mr. Lindquist stated that he drinks a lot of water, and there were other reasons for the dilute screen. So his case manager at the HPSP suggested that he see a medical provider regarding the issues in hopes that it could resolve them and that his screens would no longer be coming back dilute. As dilute screens are a violation of the toxicology screening protocols at the HPSP and thus a violation of his participation agreement. Again, on July 1st of 2014, Mr. Lindquist's HPSP case manager spoke with him again about the dilute screens. Mr. Lindquist indicated he was under a lot of stress and refused to see a medical provider regarding the dilute screens. On August 8th, 2014, Mr. Lindquist again submitted a required toxicology screen, and the results were dilute. He was notified regarding the dilute screen by his HPSP case manager on August 11th of 2014 and simply responded that he could be then reported to the board. Because of his noncompliance, the HPSP discharged Mr. Lindquist from the program unsatisfactorily. He had a total of 3 dilute screens and was not compliant with his participation agreement. The review panel believes that a suspension for 12 months is appropriate in these circumstances because he, in an effort to allow Mr. Lindquist to still be able to practice, he needed to comply with his participation agreement and be able to be monitored to ensure he was not abusing alcohol or any other type of substances. However, if he's providing dilute screens, the HPSP is unable to monitor him because they can't use the screens. So as such, the review panel believes that 12 months suspension, and when he would re-petition, if he chooses to do so, be able to show 12 months of uninterrupted sobriety is essential in order to protect the public in this case. So I would like to reserve the rest of my time for rebuttal. Thank you.
Ms. Middleton, you'll have 10 minutes remaining.
Do I get to say
Thank you.
something?
Yes.
Mr. Lindquist, you may now present your argument.
There's really no argument. I don't know if anybody here knows how the renal system works. I don't know if there's anybody that's even aware of how HPSP works. I do drink water, and what I remember is that chemicals are not washed out of your urine, even with dilute urines. There was never any positive UAs for any substances, and I had to repeatedly go back there. Mary would call me, and I went back. I'm more than willing to give up my nursing license. You know, I'm sick and tired of nurses anyways. And that's not a slam on nurses. That's just you guys have gone in the wrong direction, and I'm ashamed of you. I'm ashamed to be part of it. So it's a good thing. Oh, bingo. It's a good thing to be leaving. I spent a career at the university and at Southdale working, and at North, and flying in the helicopters with Lifelink. And all of you make me sick. And that's not anything bad. It's not a judgment. It's just that you went in the wrong way. You know? You're handmaidens to big corporate things that collect information on people unnecessarily. And I don't need a suspension for 12 months. I will freely give up my nursing license. Minnesota doesn't require any other healers to be licensed. And you can't take my education away from me. You can take my license, which I freely give up. And I hope you do take it. You know, and I hope you think about that. What kind of nurses are you that sit around and judge other nurses? You know, granted, I taught so many nurses in my career. So I'm more than happy to give it up, start a different practice on my own without your permission. With my education and all my knowledge taken with me. And then you can think about that, what you're doing. And that's it. That's all I have.
Thank you, Mr. Lindquist. Ms. Middleton, do you have any rebuttal?
Just simply that the review panel respectfully requests that the board adopt the proposed findings of fact, conclusions of law and order that was submitted earlier. Thank you.
Thank you. Do any members of the board have questions for either party? Hearing none, at this time, the board's advising attorney will read instructions to the board.
Members of the board, your role in this matter is to review the record as a whole, hear independently, and issue findings of fact, conclusions of law, and a final order. Your decision must be based exclusively on the record or on any matters on which administrative notice has properly been taken. Your decision must be in writing and must include findings of fact and conclusions on all material issues. The listing of the items in the record has been provided to you, and the record itself made available for your review. You may use your experience, technical competence, and specialized knowledge in evaluations of evidence in the hearing record. You may give probative value or weight to evidence commonly accepted by reasonable, prudent persons in the conduct of their professional or business concerns. The burden of proof in this case rests with the board's review panel. The panel must have proven by a preponderance of the evidence one or more of the various allegations set forth in the notice. A preponderance of evidence has been defined as a greater weight of evidence. In other words, that evidence which is more credible or convincing than the opposing evidence. Board members who do not regard themselves as being able to reach a fair and impartial decision should disqualify themselves from voting. In addition, any board member consulted during the course of investigation of the case or who assisted in the prosecution or defense should disqualify themselves. Board members who have actual bias or a direct, current, or formal financial or professional relationship with the respondent should disqualify themselves as well. This concludes the instructions.
Thank you. Would the review panel's attorney, any board staff who have assisted the review panel, and Mr. Lindquist please excuse themselves from the room while the board deliberates this case.
We ask that Mr. Lindquist be asked to take his computer with him if he's recording this.
Really?
Yes,
Don't I have
really.
permission to record the board?
No,
Oh.
this is a closed